So you may have heard by now that T.I. and Tiny are suing the makers of the LOL Surprise dolls over what they say is a likelihood of confusion and trademark infringement for the OMG girls. If you don't currently follow me, I'm Attorney Jones, an intellectual property attorney that has been using this ongoing T.I. and Tiny litigation to help educate small business owners about how to protect their brands. So I reviewed a lot of the filings in this case. And one of the things that sticks out to me the most is that there are no citations of actual filed registered trademarks in this lawsuit. And there's likely really good reason for that. That is a good lesson for small business owners learning to protect their brand. So I went over to the United States Patent and Trademark Office to see exactly what trademarks existed for OMG Girls as well as for the LOL Surprise dolls. And one thing that popped out, which is an important lesson, it appears here that Tiny and maybe one of her business partners attempted on their own to file for a trademark registration for OMG Girls a couple of times. These trademark filings date back to the early 2000s, 2009, and 2010. And while there is currently a filed and active trademark for OMG Girls that was recently filed in about 2020, having a trademark registration that would have dated all the way back to 2009, 2010, when Tiny first attempted to apply on her own, may have helped them in this trademark case. But those trademark applications were denied. But those trademark applications could have made it to the end of the process. Received what's called an office action, which is the way that the United States Patent and Trademark Office says that they object. And those objections could be really small things that can be fixed, or sometimes really big issues that simply cannot be overcome. But when really busy business owners like Tiny try to apply for a trademark on their own, they often lose from little technical reasons. The United States Patent and Trademark Office is very behind in reviewing applications, and so it may be several months before an applicant receives a response. And when they receive that response, sometimes, depending on if you know enough about trademark law, it reads like it's Chinese. While I encourage all applicants to hire a United States attorney to assist them with their trademark, if you're going to do it yourself, don't make Tiny's mistake. There are attorneys like me who will pick up an application at the office action stage and help you get it to the end. While those applications may not have been a deciding factor in this case, it would have been really good evidence that would have helped to support T.I. and Tiny's theory that LOL Dolls is infringing on their brands.